contracts are valid, but it is not binding and it's not enforceable. And it doesn't have a remedy, but they can be ratified. The reason why it is defective is when the contracts are unauthorized or when there is lack of authority or form. Also, when both parties are not capacitated and when the transactions are under the statute of frauds.
Example of an unenforceable contract is when a person forces to sign an illegal agreement that threatens him with a gun if the person doesn't sign. Therefore, it is an enforceable contract which undue influence or duress was involved, which is the use of power or threats or violence to force someone to sign a contract. Example is when the party's name was entered into a contract without his or her authorization. Binding force. While other contracts such as rescindable and voidable contracts are valid and enforceable when annulled or rescinded, unenforceable contracts, in the other hand, is valid but unenforceable in court unless it is ratified. Once it is ratified, then it may be enforceable.
There are three kinds of unenforceable contract. First is those contract that has been entered in the name of another by one without or acting in excess of authority. It just means that in every contract, it is important that the parties or person involved have a full knowledge and accepted or agreed to all of its terms. If a person entered into a contract without his legal approval, then the contract considered as unenforceable. But it can be cured by the process of ratification. But what is ratification? Ratification is the process of confirming about the something in legal and official way. The second kind of unenforceable contracts are those that do not comply with statute of frauds. If the contracts that created are required to be under statute of fraud, the principle of it must be followed in order to avoid fraud and to have a safety measure in any kind of mistake or error. But in case it is contrary to the statute of fraud, then the contract is considered as an unenforceable since it doesn't meet or express the real intention and agreement of the parties. However, it must prove that there is a fraud or mistake by providing concrete evidence. Lastly, the third unenforceable contracts are those where both parties are incapable of giving. If both contracting parties are incapable of giving consent, it's considered unenforceable, unless there is a ratification occurred by their guardians or parents. This kind of contract will be discussed further under Article 1407. Now, let us discuss the meaning of an authorized contract. When we said unauthorized contract, these are the contract that has been entered at the name of another person. Just like what I said earlier, if the contract that has been entered without the legal approval of the third person, it is considered as unenforceable. In simple word, unauthorized contract are also unenforceable unless it is ratified.
In 1677, the English Parliament enacted a statute to encounter the evil practice of giving false testimony in actions founded on certain kinds of contracts. It attempted to deal with the prevalence of successful perjury by making specified contracts unenforceable unless evidenced in a prescribed manner, in general, by a written memorandum signed by the party against whom liability under the contract was sought to be enforced.
Purpose, the statute of fraud has been enacted not only to prevent fraud but also to guard against the mistakes of honest men by requiring that certain agreements are specified. Those that are susceptible to fraud must be in writing, otherwise they are unenforceable by action in court. Unless they are in writing, there may be no palpable evidence of the intention of the contracting parties, and the court must be aware of no other evidence than the mere recollection or memory of witnesses, which is many times faulty and unreliable.
Number 3. Writing under the statute. The statute does not require that a contract be contained in a formal written document. The writing may be embodied in a slip of paper, a letter, a note or memorandum by means of a pen, a pencil, or any mechanical devices as long as it is intelligible and records the intent of the parties.
The statute of frauds is not applicable in actions which are neither for damages because of the violation of a contract, nor for the specific performance thereof. Thus, the purchaser of a parcel of land may prove the oral contract of sale in a subsequent action for ejectment against a third person who is in possession of the property.
It is applicable only to completely executory contracts and not to contracts which are totally executed or partly executory. The reason is the partial performance, like the writing, infringes reliable evidence of the intention of the parties or the existence of the contract. A contrary rule would result in injustice or unfairness to the party who has performed his obligation, for it would enable the other to keep the benefits already derived by him from the transaction, and at the same time evade the obligation assumed or contracted by him thereby. Furthermore, these contracts cannot be categorized as enforceable where partisans themselves have enforced them with partial execution or by accepting benefits thereunder.
Not applicable where the contract is admitted expressly or impliedly with a failure to deny specifically its existence. No further evidence thereof of being required in such case.
It is applicable only to the agreements enumerated therein. Thus, an agreement creating an easement of right of way is not covered by the statute since it is not a sale of real property or of an interest therein.
E. It is not applicable where a writing does not express the true agreement of the parties, because the statute cannot be used as a shield for fraud or as a means for the perpetration of it. Statement means that the statute, which allows the contracts to be formed through a writing that records the intent of the parties, cannot be used as a way to protect fraud or to facilitate fraudulent conduct. F. It does not declare that the contracts infringing it are void but merely unenforceable. States that contracts that violate a particular statute or law may not necessarily be void but rather unenforceable. Defense of the statute of frauds may be waived. Means that a party would ordinarily be able to use the statute as defense to avoid enforcement of a contract may choose to waive that defense and proceed with the contract. H. The defense of the statute of frauds is personal to the parties and cannot be interposed by strangers to the contract. Means that if a third party who is not a party to the contract attempts to enforce the contract or seeks to have it declared unenforceable, they cannot rely on the defense of the statute of fraud to support their claim. The 6 contracts that fall under the statute of frauds will be discussed next.
A contract does not have to be in writing to be enforceable. In fact, most contracts made orally are legally enforceable. However, there are instances which fall within the scope of statute of fraud which are not legally enforceable in court although valid, unless the same be in writing. In other words, if either party refused to comply with their agreement, the same could not be enforced. The first one is the agreement not to be performed within 1 year from the making thereof. For example, A entered into a contract to build this house to begin after a year the contract is perfected. The contract must be in writing to be enforceable. In order that this provision be applicable, it must appear that the parties intended, when they made the contract, that it should not be performed within a year from the date the contract is entered into by the parties, and not from the date it is to be effective. The contract is within the statute if the time for the full performance of the contract exceeds a year, although the excess is ever so little, even for 1 week or 1 day.
Promise to answer for the debt, default, or miscarriage of another. If it is a collateral promise of suretyship, a commitment to pay the debt of another person must be supported by written documentation. A collateral promise is a commitment that is added on top of or in support of another promise. One who guarantees performance in the event of another's default is known as a surety of guarantor. For instance, A and B agree to pay C. Here, both A and B are making a direct promise to pay C. Although A is listed first, both are promising to pay C. Now consider this. B agrees to pay C if A does not. Here it is clear that there must be another agreement somewhere for A to pay C, but that is not contained in this promise. Instead, B is entering into a contract with C as a collateral or as a side agreement. In the pledge A is making to C. In some cases, this commitment to pay C if A doesn't and the other agreement for A to pay C are contained in the same document. Thus, does not change the distinction between this promise and a collateral promise. Next is the agreement in consideration of marriage other than mutual promise to marry. The statute of frauds demands that any aspect of a marriage or pledge to marry that also includes a promise to exchange something for it to be documented in writing. Mutual promises to marry are not within the rule. For example, Franz and Ali exchanged pledges to get married. If no written proof of this was provided, the pledges would still be enforceable. However, if Ali believes Franz to have said, "If you marry me, I will deed to you my property in Tagaytay," the promise regarding the property would need to be supported in written documentation in order to prevail over Franz's denial. Such promises are subject to the statute of fraud, regardless of who makes them. If Franz's father had promised to give him $1 million if he married Ali and started a family, let's say Franz would have accepted and wed Ali. If the father disputes it, the pledge is not enforceable unless it is in writing.
For sale of goods, chattels, or things at a price not less than 500 pesos. An agreement for the sale of goods, chattels, or things in an action for a price not less than 500 pesos to be enforceable, it must be in writing under the statute of fraud. For instance, A and B entered into a contract of sale involving a laptop for a price of 10,000 pesos. The law said that it must be in writing to be enforceable. If the contract of sale is made orally, then that contract is unenforceable under the statute of frauds. However, if the contract of sale involving a thing not less than 500 pesos is made orally and one of the parties has already paid half of the price of the thing as a down payment, and there is a receipt acknowledging the down payment, can you enforce the contract? The answer is yes. Why? Although the statute of fraud states that this type of contract must be in writing, it is also important to note that the statute of fraud only applies to an executory contract or a contract that has not been performed yet. In the example above, because the down payment was already made and an acknowledgement receipt was already given, the contract of sale is no longer executory. Note that the statute of fraud does not apply to partially executed contracts. Agreement for leasing for a longer period of time than 1 year. For example, C entered into a contract of lease with D that agreed to rent his property to C for 4 years, and it was made orally. The contract is unenforceable because the statute of fraud requires it to be in writing for it to be enforceable. The exception is that even if the contract of lease for 4 years was made orally, and if the payment of the advance lease was already made, the contract is now enforceable. Because the statute of fraud, again, does not apply to partially executed contracts.
Agreement for the sale of real property or of an interest therein. It outlines the terms and conditions of the sale, including the purchase price, payment terms, and any contingencies, such as obtaining financing or a satisfactory reduction. The agreement will also include a legal description of the property and any personal property that is included in the sale. Both parties must sign the agreement to make it legally binding. The statute of fraud mandates that all agreements should be made in writing. So if the agreement is only made orally, then that is unenforceable. It is important to consult with a real estate attorney to ensure that the agreement is valid and enforceable. For example, Dambo orally sold his land or his right of usufruct and said land to B. The agreement is unenforceable. As stated in the example, the agreement was made orally. It is therefore not enforceable. According to the statute of fraud, the agreement must be in writing to be enforceable. And lastly, representation as to the credit of a third person. A representation of a third person must be in writing to be enforceable. A third party is not responsible for the other party's debt if the representation was only made orally, and therefore unenforceable. For example, A seeking loan from B. C represent to B that A is solvent and has a good reputation as to credit. B, relying upon the representation of C, B extend a loan to A who actually is insolvent. The representation of C must be in writing to be enforceable.
Article 1404. Unauthorized contracts are governed by Article 1317 and the principles of agency in Title X of this book. So in Article 1404, that is governed by Article 1317, which states that no one may enter into a contract on another person's behalf unless they have that latter's consent or unless they are legally permitted to do so. A contract entered into another's name by someone who doesn't have authorization, legal representation, or who acted without knowing his or her rights is unenforceable, unless it is ratified expressly or impliedly by the person on whose behalf the contract was signed before it is cancelled by the other contracting party. Article 1405. Contracts infringing the statute of frauds referred to in number 2, Article 1403 or ratified by failure to object to the presentation of oral evidence to prove the same, or by the acceptance of benefits under them. Modes of ratification under the statute. Article 1403, Statute of Frauds, paragraph 2 may be ratified in two ways. Number 1, by failure to object to the presentation of oral evidence. This is a tantamount to a waiver. Contracts that are infringed in the statute of frauds are ratified by the failure to object to the presentation of parole evidence or the agreement that is not contained within the written contract and are enforceable. The requirement of a written form is for evidential purpose only. And the second one is by the acceptance of benefits under these arrangements constitutes waiver or stoppel. In this case, the contract is no longer executory and therefore the statute does not apply and only applies to executor contracts. If the party charged reduces the oral contract to writing, this is known as recognition. It is the contract's express ratification. This rule is based on the well-known idea that the person who has benefited from a transaction shouldn't be permitted to reject its obligation. If the party in whose favor the statute may be applied examine the witness testifying on the written contract, the latter is deemed to have waived the right to object to the admission of the witness testimony. As soon as it becomes clear that no written proof can be used to support the contract, the party should immediately object to the witness's testimony. An answer to the complaint may be filed before the objection is raised, but it must be raised during the witness's offer of the testimony in order to be considered.
Article 1406. When a contract is enforceable under the statute of frauds and a public document is necessary for its registration in the registry of deeds, the parties may avail themselves of the right under Article 1357. Right of a party where a contract is enforceable. A legitimate agreement must be present for this provision to be totally applicable and it cannot be violated by the statute of frauds. As per law, one party involved in a verbal transaction is a real property cannot be forced to other to record agreement publicly for registration objectives. This is because the contract is valid and can be enforced except if it has been validated or ratified. The entitlement of one party to compel the other party to sign a public document cannot be exercised in the division of realty when it contained in a private instrument since the donation is void or invalid. If a party initiates legal proceedings over a contract, they can also request the court to mandate the other party to create a public document containing the written agreement or memorandum.
Article 1407. In contract where both parties are incapable of giving consent, express or implied ratification by the parent or guardian, as the case may be, one of them, the contracting party, should give the contract the same effect as if one of them were incapacitated. Contract is unenforceable if both parties are incapable to consent. So when does an enforceable contract becomes a voidable contract? The contract is voidable if either parties, parent or guardian, as applicable, or one of the parties acquiring or regaining capacity, ratifies it. Ratification is made by the parents or guardians, as the case may be, of both contracting parties. The contract shall be validated from the inception.
Enforceable contract becomes valid contract. In this case, the statement means that if both parties to the contract ratify it after it was first entered into by their parents or legal guardians, or if both parties ratify it after acquiring legal capacity, the agreement will be considered valid as of the time it was first entered into. In other words, ratification is in effect of certifying the agreement going back to its beginning, as if it had been binding law from the beginning. Crucial legal theory because it permits the retroactive validity of contracts that may have been previously invalid or unenforceable, provided certain requirements are met.
Article 1408 states that unenforceable contracts cannot be assailed by a third person. In other words, a third person cannot question a contract because of its unenforceability, just as they cannot attack the validity of a voidable contract. Indeed, the benefit of statute of frauds can only be claimed by one who is a party to the oral contract. That defense is personal to the party involved to the agreement. To further explain this article, I will give you some examples. A sells a parcel of land to B. The contract was oral. C binds himself in writing for the performance by B for his obligation to pay the purchase price. In an action by A to recover the purchase price, C cannot assail the contract between A and B, being unenforceable under the statute of frauds, because C is stranger to the contract.
A disagreement between a debtor and a third-party buyer of mortgage property is at issue in the case of Limcatay Sons Milling Incorporation versus Court of Appeals, Bank of the Philippines Islands, and National Bookstore. Limcatay Sons Milling Incorporation, the petitioner, mortgaged its assets to the Bank of the Philippine Islands as collateral for a loan. The National Bookstore, who was aware of the financing, bought the property afterward. The petitioner then filed a lawsuit for damages against the bank and the buyer, claiming that the sale was done in bad faith and against its right as a mortgagor. The Court of Appeals overturned the decision of the trial court, holding that the buyer acted in good faith and that the sale was legitimate. The trial court had found in favor of the petitioner, although the buyer was not an innocent purchaser and the buyer's poor faith was made worse by the bank's refusal to do so, according to the court. In the end, the Supreme Court ruled that the buyer must compensate the petitioner for the loss of the income brought on by the buyer's possession of the property. The bank was required by law to disclose the mortgage to the buyer for value because it was aware of the mortgage at the time of the transaction. The Supreme Court agreed with the petitioner, ruling that the sale was done in bad faith and that the buyer was not an innocent purchaser for value. It is not considered as an enforceable contract because there is a clear and convincing evidence that provided in a written instrument. For example, the agreement or authorization of Rebelia to sell the property.
Gamaliel C. Villanueva and Irene C. Villanueva, petitioners, versus Court of Appeals, spouses Jose and Leonida de la Cruz, and spouses Guido and Felicitas Pile, respondents. Juror number 107624, January 28, 1997, Panganiban. Facts. Cruz is selling a plot of land with a three-door building and Villanueva shows an interest in the land. Since the said property was in overdue debt within the installment of the realty changes, Villanueva gave 10,000 pesos to pay the charges and would frame a portion of the deal cost of 550,000. However, Cruz signed in favor of the bill being uphold and the deed of transfer of the land where Villanueva's apartment is located. Villanueva learned of the new transfer assignment and title deed in favor of the PB and his wife and proclaimed that there was an agreement that said part of Cruz's land would be sold to him. De la Cruz says he never agreed on the final price for the property in question. In fact, he strongly rejected any price deal with the claimants because he quoted the price as 575,000 pesos and did not agree to reduce it to 550,000 pesos, like Villanueva declared. Villanueva argued that 10,000 pesos was an advance or partial payment to the property. Therefore, there must be an agreement on the price, hence a perfect sale. De la Cruz contradicts this assertion by arguing that 10,000 pesos, primarily for the payment of property taxes, will be part of the review of the sale if and when the transaction is finally completed and confirmed, determined that he had no definite agreement on the actual amount of the review.
Issue. Under the factual circumstances of this case, was there a perfected contract of sale? No. The sale is consensual contract. Its informer must prove its existence with accurate evidence. Here, the much-needed element of price has not been proven. What took place was just a lengthy negotiation to buy and sell, and at most an offer and a counter-offer. But the parties failed to reach a final agreement. There is no agreement on price, express or implied, direct or indirect. Therefore, the award is hereby rendered dismissing the plaintiff's immediate action for specific enforcement. However, Respondent Jose de la Cruz is hereby ordered to reimburse the amount of 100,000 pesos to the applicant.
The case of Rosario Carbonell versus Jose Poncho, Ramon Infante, Emma Infante discussed the matter in question whether the statute of fraud is applicable. Petitioner Rosario Carbonell allegedly purchased a parcel of land from respondent Jose Poncho. Such land was mortgaged to a bank which respondent has an obligation to pay. It was alleged that the petitioner paid the respondents a portion of the land's purchase price and took on respondents' obligation to recover the land. One of the conditions of the alleged sale was that Poncho would be allowed to continue staying in said land for 1 year. However, Poncho has conveyed the same land to the other respondents, herein which are the spouses, Mr. and Mrs. Infante. Respondents herein claims that the previous sale between Poncho and petitioner was unenforceable due to a violation of the statute of frauds, as the alleged sale was never deduced to writing. Petitioner here claims ownership of the said property. In this instance, it appears that Poncho persisted in asking the petitioner for authorization to stay on the land. Additionally, it was shown that the petitioner was in possession of Poncho's passbook, which is said to have a credit account that presumably represents the petitioner's part of the payment. The court says that Carbonell is entitled legally as well as from the viewpoint of equity to an opportunity to introduce parole evidence in support of the allegation of her second amended complaint. Thus, the order appealed from is set aside and the case is remanded to the lower court for further proceedings, with the cause of this instance against defendants appellees.